Griffith for 5 minutes.
Thank you, Mr. Chairman. Following up on that, Mr. Siegel, I was intrigued with some of your comments in regard to what Ms. DeGette was just talking about, some ideas. And I believe, if I remember your testimony correctly, what you indicated was that if you were going to send a letter of this nature, because you might have a legitimate claim, then make it a requirement that that claim be stated up front. Did I understand that correctly, and would you expand on that, please?
That is correct. If they actually had proof that they did proper due diligence to have a reasonable belief that we infringed, we would happily discuss the infringement contentions with them and try to come to a resolution if they were in good faith. It's very clear from the letters we've been getting that they do not have that good faith intention. It's spray and play. All the demand letters are all the same, just with a different company name.
And so all they say is, we have reason to believe that you may have violated the terms of our patent and therefore pay up.
And then when we called them, LumenView, it was very clear they hadn't even been to our website, didn't really understand the functionality, didn't even understand their patent that well too. So it's very hard to deal with the situation when they are actually more concerned on the cost of defense as their main reason for exercising these demand letters, opposed to the merits of the infringement.
Right. Of course, it's not always easy to figure that out, and somebody may have a legitimate claim, even though their motives may not be great. They may actually have a legitimate claim. But it does seem to me that we ought to be able to work out some language, probably in the Judiciary Committee, but perhaps we can in this committee as well, figure out some language that ought to be included in that letter that would be a requirement that you notify the company prior to filing a lawsuit. I don't think you can say necessarily the first letter, but you could say that prior to filing a lawsuit on such a claim, you have to provide the defendant company with the follower defendant individual, whichever it may be, with the following information, and then go A, B, C, D, E, to basically, to state a reasonably articulable theory of why you think you've been damaged.
Yes, and at a very minimum, the claims in the patent that they're actually inserting, there's usually lots of claims in a given patent. And in our case, they don't mention which claims. And so that has an undue amount of work and time and effort on our part to then have to research every claim. So at a minimum, they should disclose which claims. So provide some evidence of due diligence, screenshots from your website, what evidence they have to believe that you infringe. And with that, we're okay with those. That shows they have a good intent to potentially resolve this issue. It's this type of behavior that we think needs to be stopped. And I think a lot of it's just because it's so easy to send a demand letter, there should be some minimum standards of what that should entail.
Well, I appreciate that very much. Mr. Richardson, you indicated that you all had gotten a letter for just linking a site. Was it the site that they were upset about, or the fact that you used linking technology? Because I'm surprised every member, if it's linking technology, I'm surprised every member of Congress hadn't gotten a letter. I'm linked stuff through my website every day.
Never know. Today's mail might not be here yet.
Yeah, well, that's a good point.
That is exactly what the claim was, and it was insertion of a hyperlink, URL into tweets, into a customer email, just to make it easier to, direct our customers who had opted in, who wanted this information, an easier path to get to it.
Wow. And then, of course, there's the safety factor, because not only are there more requirements in regard to service of food, as your industry does with White Castle and lots of other fast food chains out there, people want to know what all those ingredients are. It's not only the calorie intake, it's, what are you actually putting in there, because food allergies are on the rise. And you're saying that you got a letter on trying to do something like that too, that you had to put on the shelf because you just couldn't afford the price of litigation?
Yeah, very similar to that, because as we're looking at new menu board technologies to make it easier to share that nutritional information or to change a price or change an offer, the claim there was that was a violation, actually because of how we were using the internet to send the information digitally. And we'd be okay if we wanted to put it on a jump drive and drive from Columbus to Louisville, but not to be able to use the internet to do that just didn't seem to make much sense to us. But that's one where they didn't even send us a letter. It went straight to litigation, as others have referenced.
Wow. That's incredible. I will tell you that that's of great concern, because particularly for the smaller chains or the mom and pops, they just don't have the ability to get that information out there if they can't put it on the internet, and that's a real problem that will affect their businesses. Mr. Chairman, I appreciate you doing this hearing. I appreciate all our witnesses being here. This is a subject area. I too am a lawyer, but I never represented corporations unless they were small mom and pops. I didn't do this kind of work, but I really appreciate this. It's been an eye-opening hearing, and thank you so much for doing it. I yield back.
Gentleman yields back.